Hi, my name is Kirsty Dixon and I'm the Planning Director for Brunswick County. Thank you for watching our virtual recording of the community meetings presentation. The project is intended to modernize and reorganize the county's development regulations to improve clarity, usability, and bring the ordinance in compliance with North Carolina law. Today's presentation will provide an overview of the proposed ordinance, including key highlights and organization changes. We appreciate your participation and continued feedback as we continue moving forward with this important project. Joining me today is Michael Harvey with InFocus Planning, the county's consulting team assisting with the development of the new ordinance and this presentation. In the future, if you have any questions, feel free to reach out to Brunswick County staff. We'll be happy to answer any of your questions. And I will turn it over to Michael Harvey.
Thank you, Kirsty, and hello all. My name is Michael Harvey. I'm the president of InFocus, and I'm the staff planner assisting Brunswick County with this update. It's my pleasure to be here today and walk you through the presentation concerning this project and provide some background as to where we've been, where we're going, and how we hope to get there. At the conclusion of this presentation, Kirsty is going to come back on and remind everybody about how they can reach out to county staff and the InFocus team with questions or concerns that we are happy to address. At this juncture, I'm going to share my screen and my presentation and walk you through the update to the Unified Development Ordinance. With that being said, this is a discussion on the development of the new ordinance, as both Kirsty and I have already alluded to. The first thing to understand and the first thing that's important to remember is that this is a project that is ultimately born of a partnership. It's not a mandate. This is a joint initiative between the InFocus firm and Brunswick County Planning and the attorney staff, where we are working in partnership to update the current regulations into a new document. We as a consulting firm are not dictating the process. Local government is managing the process with InFocus. We view ourselves as an extension of existing planning staff to help facilitate the completion of this project. Both parties are addressing local needs consistent with applicable state law as well as the adopted comprehensive plan, which we'll talk about in a little more detail as we go through the presentation. This project began in the summer of 2024. And originally, as you'll note from my slide, InFocus and local staff had anticipated that we would have a new adopted ordinance by May, June of 2025 or last year. So what happened? Unfortunately, during our work on the project, several bills began to be reviewed by the North Carolina General Assembly that impacted local government regulation and enforcement of land use standards. Specifically, the largest change was the adoption in December of 2024 of Senate Bill 382 that effectively established limitations on local governments being able to engage in downzoning, which we're going to talk about a little bit further into this presentation. With the concerns as to whether or not we could actually continue and finish this project, InFocus and the county actually agreed to cease work. So number one, the county was not being billed for work that was not being done. But number two, it gave us time to get a better handle on how we were going to be able to comply with the new regulations governing downzoning, as well as other bills that were being reviewed at the General Assembly level. In the fall of 2025, both InFocus and the Planning Department and management with Brunswick County decided we needed to move forward as best we can. And as a result, my firm is effectively creating multiple options to ensure how a new ordinance can be adopted that will be consistent with state law. As my firm has already told county commissioners and county management on several occasions, our ultimate responsibility is to ensure we're giving you an ordinance that complies with state law and does not subject the county to litigation in terms of challenging the validity or enforceability of the standard. Local staff and Infocus are obligated to ensure this update does not create inconsistency with state law. And as such, that has resulted in a delay in getting the project completed. I should point out, as we move forward through this presentation, there are several bills that are currently still going through the General Assembly, which could impact the county and application of land use regulations. Specifically, a local bill that potentially changes the approval authority observed in Brunswick County. Currently, your planning board has final review and approval authority over several projects, with appeals being sent to the elected officials, the Board of County Commissioners. This local bill would eliminate the planning board's authority to have any final approval or say on a project, specifically rezonings, and they would be obligated to make recommendations, with the elected officials being the final responsible entity to either approve or reject a rezoning change. There's also changes to the downzoning regulatory standards that we will explore in greater detail herein. These changes will impact some of the options the county has in terms of implementing this ordinance. There are bills going through the General Assembly now that would prohibit units of local government, either municipalities or counties, from implementing and enforcing parking regulations. That will also have to be taken into consideration as we move forward. There's also bills requiring and mandating that housing be permitted in all commercial general use zoning districts. So as you can see, moving forward, we have a lot of issues that we are attempting to resolve and ensure consistency with applicable statutory authorization. So from an ordinance update standpoint, we have several opportunities and constraints, some of which I've already reviewed. The opportunities is that this is being done in a cooperative work environment. This ordinance update is being done with involvement with the public, members of the development community, members of local stakeholder groups, including housing advocates and conservation advocates. This is going to help make this project a success. One central theme that the county planning staff has asked and focused to follow is that we need a simplified land use ordinance that'll be easier to follow from not only the development community, but the average layperson in the county who wants to understand what opportunities exist with respect to the development of property. The ultimate goal is to ensure we have an ordinance that is easier to administer and enforce for local staff. One central theme you will note as we go through this presentation: the county is doing this update to ensure proper implementation of the new comprehensive plan, specifically the Blueprint Brunswick 2040 plan. As a general reminder, land use regulations and the ultimate responsibility as articulated in the comprehensive plan with respect to implementing land use regulations is to address the public's health, safety, and general welfare. All decisions related to land use activity follow that same tenet of importance as it relates to what is and is not going to be acceptable within Brunswick County. We have an opportunity to ensure balance between the need to allow development while protecting the local environment, specifically natural area, which we will define further in this presentation. This also gives us the opportunity to partner with diverse interest groups. That includes the development community, the general public, members of local conservation entities, housing advocates, and etc., to devise an ordinance that tries its best to meet all diverse individuals' needs while still following the goals and policies of the adopted comprehensive plan. The constraints that we have to deal with include ensuring that we are tracking and consistent with current state law as we finalize the document. As I have previously indicated, we are having to prepare multiple options to address possible impacts to ensure that we're providing Brunswick County proper guidance on how best to move forward. We are also required and obligated to address and manage public expectations of this project, specifically the expectations of reality. As we will talk about later, this ordinance does not establish moratoria on development opportunities. It does not establish constraints that are inconsistent with state law. It does, however, have to ensure that we are properly implementing the comprehensive plan. We also, as a matter of policy and law, have to ensure the reasonable use of property. So as we move forward and are making decisions, we have to keep the tenant in place, that we have to guarantee that an individual is allowed to make reasonable use of his or her property moving forward. So what we are here to discuss during this presentation is to provide an update on the development ordinance process. We are going to discuss the consolidation of regulations and summarize current recommendations as it relates to how this ordinance is going to be restructured. As we begin, it's important for everyone to understand what a development ordinance is. The general definition is referenced under state law, is that it is a document containing applicable land use regulations, which could be zoning, i.e. land use, subdivision, how parcels of property are divided into single lots, design guidelines, flood regulations, stormwater, parking, signage, watershed, etc. Everything being combined into a single document. This is ultimately to assist local governments respond to development opportunities and constraints by helping developers and the general public avoid overlapping regulations and understand what they are obligated and not obligated to do. Per the applicable general statute, local governments are authorized to combine these regulations into a unified ordinance, creating in effect a one-stop shop for permitting and development information for all parties. That includes members of the development community and members of the general public to understand what opportunities they have to participate in local processes. You will note as we go through this document, there is going to be a rebranding of the current Unified Development Ordinance into what is called a Land Development Ordinance. Questions have been posed about why we are rebranding. The simple explanations are as follows. We, both at InFocus and local planning staff, want to create a distinction between current and pending regulations. The name change will help facilitate people understanding that there's been a shift from the Unified Development Ordinance construct to the new Land Development Ordinance construct as a way of helping to signify that there's been an adoption of new regulations and new standards. Both InFocus and local staff believe the term Land Development Ordinance is more in line with what the overall purpose and intent of the updated ordinance is. And also it reflects current policies, goals, and language within the adopted comprehensive plan, specifically Blueprint Brunswick 2040. We're also hoping that the rebranding will help avoid confusion over past documents and regulations, allowing the county to move forward with this new concept and provide a clean break from what people may remember was enforced previously to what is going to be enforced now. Ultimately, the overall purpose of this project is to ensure consistency with the adopted comprehensive plan. I know you've all have heard me say that before, but it's important to recognize that the Land Development Ordinance, or LDO, is going to be the chief implementing document for this plan. It is the primary document utilized by staff to ensure that the goals, policies, and objectives as articulated in that plan are properly implemented, ensuring the public's health, safety, and general welfare. We also have to ensure consistency with state law, specifically North Carolina General Statute 160D, which is the chapter and provision of the general statute giving units of local government the authority to implement land use development regulatory standards. This is a high priority for us. InFocus obviously has an interest and a desire to ensure that we are not setting the county up to fail by giving them an ordinance that effectively could see them be taken to court for not being compliant with the authority under the state statutes. We have a moral and legal obligation to ensure that the county is on proper footing as they begin to implement the ultimately adopted new Land Development Ordinance. We are going to be updating implementation strategies from the current UDO to the new LDO. This will ensure all available tools are properly managed, or properly incorporated to manage development within the actual document itself. We need to ensure that the community's vision for growth and development are articulated. Most notably, that's why we are following the Blueprint Brunswick plan so closely. And we need to streamline ordinances, make them easy to use and easy to enforce. To address comments we've heard from previous outreach meetings, there is a concern that obviously this will mean that the county is going to be soft on development. And I am pleased to say that that's not going to be the result of this new document. We are, however, going to be working to encourage practical development that meets the goals, policies, and strategies as articulated in the adopted Blueprint Brunswick 2040 plan. So with that, what does this project do? As you all have already heard, it is addressing consistency with the adopted comprehensive plan. It is going to be reorganizing and consolidated review processes. As you will note as we continue this presentation, there are several instances where review processes are actually scattered throughout the entire document, requiring an interested party to read the entire UDO to understand what responsibilities exist with respect to going through a development review process. County staff have asked us to work to ensure that there's consolidation of these activities into central articles so that not only staff but the general reader will not have to go through multiple chapters to find answers to basic questions. We're going to be reorganizing and rebranding existing zoning districts on the table of uses to make it more user-friendly and understandable. We are adding the stormwater ordinance to this new document, which is currently enforced by the county engineer. While they are currently a partner in the review process, this will broaden their involvement in looking and reviewing at land use development proposals. We're also updating landscaping, open space, natural area preservation standards, and ensuring that we have content neutral sign standards consistent with U.S. Supreme Court determinations. As I've already indicated, what this ordinance does not do is establish a development moratorium. It does not prohibit multifamily housing. We can't do that from my standpoint and be consistent with state law. Unfortunately, we are also not going to be establishing a tree protection or preservation ordinance as has been requested. While InFocus understands and believes there is a need for this type of regulatory standard, the county at current has no statutory authority to do so. I want to remind those listening to this presentation that the elected officials for Brunswick County and local staff have advocated on numerous occasions to the General Assembly to get this authority. As of yet, they have not been successful. And while they continue the good fight, we cannot adopt or implement such an ordinance without the General Assembly's permission. I also want to remind all parties consistent with current policy and regulations, the LDO will not allow or encourage a public veto of development projects. That is not something currently permitted under state law. While there's opportunities for the general public to be involved in the development review process, the general public as a whole does not get a vote on whether or not a project complies with the ordinance or complies with the provisions of the comprehensive plan. Those determinations will be made by staff, appropriate advisory boards, and then ultimately the elected officials. So from a project description standpoint, we are reorganizing the current UDO as part of this new land development ordinance as follows. We are updating existing general provisions. That is the new Article 1. This ensures that we're properly referencing the county's authority per state law to actually engage in the development review and enforcement process. We're also taking great pains to ensure that there's appropriate reference to bona fide farm exemptions as currently outlined under state law as embodied in the current UDO. As a general reminder, units of counties have no regulatory authority to enforce land use standards on bona fide farm activities. That includes what's defined under state law's agritourism components to a bona fide farm. We're updating language on zoning map and ensuring consistency again with the adopted Blueprint Brunswick Comprehensive Plan. We are streamlining and redefining how zoning district boundaries are determined by staff. We're including standards on transitional provisions. To summarize what that means, if an individual property owner submits an application today to develop a parcel of property, and the Land Development Ordinance or LDO is adopted on Friday by the county, that would change the overall scope of what is and is not permitted with respect to that project's compliance with the code. We are not going to arbitrarily deny a property owner's right to have sought development review and approval authority for a legal land use that existed the day they filed the application. So ideally, an individual that files an application, as allowed under current state law and as reflected in your current Unified Development Ordinance, have options, what's called permit choice. They can choose to follow the standards of the current ordinance versus the LDO, which may have created issues for them to be able to implement their project. As a general reminder, this is only during the time period upon which the new ordinance is adopted. As we move forward and applicants submit new applications, they will be reviewed under the new adopted Land Development Ordinance. We've also added new standards dealing with state of emergency authorization, specifically language that would allow the county commissioners to establish and declare a state of emergency to address natural disasters, which would suspend certain permit requirements from a zoning standpoint as local staff help and address impacts to local property owners from a natural catastrophe, whether that be a hurricane, tornado, or etc. The goal is not to overly penalize local property owners attempting to establish temporary housing, for example. The goal is to try to help facilitate some of their needs during the actual state of emergency and ensure that we help them get on the best path forward to making themselves whole. Articles 2 and 3 of the revised LDO deal with centralized administrative and review procedures. All administrative and board provisions, specifically, what is the role of the county commissioners in the land development process? What is the role of the planning board? What is the role of the staff? What is the role of a board of adjustment, etc., are now going to be located and defined in a central article. We're also expanding and defining staff authority. There is going to be references to staff authority consistent with not only current regulatory policy, but consistent with current state law. All permit procedures are now going to be located in one central article. Current staff have done a great job of organizing the current UDO to address this. There are, however, certain provisions that are located in multiple chapters, and one of the charges from Ms. Dixon as the planning director for Brunswick County is to consolidate and simplify these procedures and policies to make them easier to follow and understand. We are also going to be streamlining zoning permit review to the benefit of all parties. This would include staff, advisory boards, elected officials, applicants, and of course the general public, ensuring that they understand what opportunities and constraints they have to participate within the process. Article 4 is going to be dealing with the definition and consolidation of all dimensional standards for the various zoning districts. As a reminder, in focus and the county staff are proposing additional new zoning districts, an agricultural and a conservation district, a heavy industrial overlay district, a new mixed-use district. In focus has also been tasked with updating references to the current airport overlay, ensuring consistency with the existing airport ordinance. We are going to be referencing place types as currently contained within the adopted comprehensive plan and the future land use map or FLUME, providing a causal link as to which zoning districts are anticipated to be allowed in those those place types or activity centers as defined in the comprehensive plan. This is just a further way that we have at our disposal to ensure that we are properly implementing the goals and policies of that plan. We are going to be working to establish allowable density and a density bonus system that deals with workforce housing and more specifically open space natural area preservation, which is going to be required. Workforce housing is effectively affordable housing designed to try to address providing areas where local residents making certain percentage of income can actually find housing that they can afford. Residential districts are now going to be based on allowable density. So as the example I'll give you, current regulatory standards establish the R7500 general use zoning district. That district is being rebranded to an R3. Why? There's bills going through the General Assembly that require a mandate that a residential district needs to reference the density that is permitted within the district. R7500, while local staff may have an idea of what that means, can be confusing. We are simplifying moving forward the naming, the nomenclature of these districts to ensure that it's readily identifiable what the allowed density is going to be within a given area of the county. This gives us pause to want to remind everyone what density truly means in the context of Brunswick County. As many know, current regulations allow for increases in residential density in the majority of zoning districts. There have been concerns expressed to county staff and in focus during various outreach meetings over this current practice, and that allowing increased density beyond what the districts require or allow is inconsistent with the nature and intent of the district. We are keeping and maintaining this allowance, and when the question is posed why we're doing this, the first answer has to be that this methodology is consistent with the goals and policies of Blueprint Brunswick, where there are various strategies for encouraging or promoting housing where that housing is more appropriate. It is consistent with existing development patterns, and ultimately it avoids potential legal challenge for downzoning or changes in allowable density per the current ordinance. As a general reminder, based on current state law, the county cannot downzone property, change density, or change development criteria without the acquiescence of impacted property owners. We cannot create effectively what's called a nonconformity. The process and focus is working on with county staff would ensure that we are consistent not only with state law, but we are appropriately referencing and implementing the provisions of the adopted comprehensive plan. I would, however, like to add that we are recommending some changes in how projects with higher density are going to be processed. To get this increase, both in focus and local staff have determined developers must preserve a minimum of 30% open space or natural area for the project. This will be reviewed as what's going to be defined as a flexible development subdivision as we move forward with this presentation, which would allow for the clustering of lots. Why is this important? Well, number one, we believe that if we're going to allow higher density, there ought to be some benefit to not only surrounding property owners, but the county as a whole. And the preservation of natural area becomes paramount for the county, as this helps address the preservation of existing trees. It helps address stormwater runoff. It ensures protection of environmentally sensitive areas, which could include floodplain, and it could also include regulated wetlands throughout the county. The ultimate goal of clustering of the lots, it reduces the need to grade the entire property, disturb the entire property to encourage and allow for the development. It does reduce development costs, which can have the side benefit of lowering the overall price of housing or even lowering the average price of rents for a non-commercial project. It preserves existing topography to the greatest extent possible, which helps address concerns over stormwater and stormwater runoff. To get more in depth as to what would be preserved as either open space or natural area, I've already alluded to special flood hazard area. This would be the 1% area of annual inundations defined on actual flood insurance rate maps, as well as the actual floodway. Jurisdictional wetlands anticipated as being protected. We are also going to be recommending a buffer around the jurisdictional wetlands within the preserved natural area. We would be looking to preserve steep slopes that are unsustainable to support development, preserving and protecting streams and required riparian buffers required by the state, active farmland, as well as heritage trees and significant forested areas. The example is an individual going through this process proposing development on 100 acres of land would have to preserve 30 acres of property as open space protected natural area. Questions have arisen about why we are including jurisdictional wetlands as natural area for open space. Wetlands do have limited development potential through the Army Corps of Engineers. Ultimately, the county cannot prohibit development activity that's been approved by the Army Corps of Engineers. The whole point of preserving these areas is to preserve the identified environmental feature that we know needs protection and protect the actual viability of the wetland as a stormwater source, and also to preserve the unique attributes of the wetland from unnecessary development activity. There's also a legitimate concern from the county attorney's office about not allowing wetlands to be counted as natural area, as this could be construed or argued that we could be engaging in a potential downzoning. As we are indicating to a property owner that you have the rights to develop your property, if there's wetlands on the property, those rights are further restricted. If the jurisdictional wetlands are actually included as open space, then they are not on subject parcels of property, and it does free up the property owner to actually make more use of their parcel without having to go through additional hoops in order to seek development approval. Ultimately, allowing wetlands to be counted as protected natural area, it's in the best interest of the county to allow that as protected space, to avoid the risk of they being developed and or impaired, or on additional standards being imposed on property owners over time that we feel could be construed as limiting their rights to develop their property. At this stage of the presentation, we'd like to answer some basic questions that always come up during the review of this project. Specifically, will the ordinance update that we're currently working on impact current residential use of property? The answer is no. We can't do that and are not planning on doing that. So for those listening to this presentation, your current land use has already been permitted and can continue operation consistent with the policies, goals, and standards, and any conditions imposed on that operation. We will not be seeking to impose additional criteria on your continued use of this property. Will there be changes to where residential land uses are permitted? The direct answer is no. In fact, with the LDO update process, we'll be increasing residential housing options throughout the county. We were asked originally questions as we began this process on how this ordinance will handle, this new LDO will handle cemeteries. I want to remind everybody that cemeteries are currently permitted throughout Brunswick County with standards and will continue to be so within the new LDO. We are going to be preserving that allowance. Existing cemeteries will be allowed to continue operation and be considered protected and allowed to continue. So this will not impact existing cemeteries that are already in operation. Will this process involve the rezoning of property? The direct answer is no. The county is not going to be engaging in any pre-zoning of property as part of this process. While we will be rebranding several districts and updating the zoning map to reflect those rebrands, it will not be a map amendment. We are not changing the ultimate zoning of your property. We are just renaming the district. Next, we have Article 5. This is the article that is going to house the table of land uses and the definitions of various land use categories. Staff is updating the table of permitted uses. We are working to ensure allowable land uses are preserved so that we're consistent with state law and it prohibits a downzoning claim. We're updating definitions of the various land use categories to provide guidance and direction to the layperson who may be reading the ordinance as to what they can and cannot do in a specific area of the county. We are going to provide a detailed explanation on exceptions, specifically what certain land uses are categorized as, to provide clarity to the reader. The local planning department's already done a really good job of this. We are taking the work they've built on and increasing examples in order to ensure that we are providing guidance to the reader of the ordinance. We're also providing an explanation of uses that are permitted by right, permitted subject to development standards, meaning you have to have increased setbacks or you have to have compliance with landscaping standards, etc. Special uses that are required to be reviewed during a pre-advertised evidentiary hearing by the Board of Adjustment, and those uses that are actually prohibited from development within Brunswick County as a whole or within specified zoning districts. The ultimate goal is to provide the reader of this document with a starting point so they can understand what they can and cannot do with their property in a simplified format that makes it easier to comprehend. Article 6 of the LDO will be dealing with general development requirements. As a general reminder, the county has an obligation to include appropriate reference to the city of Northwest as we enforce their ordinance. We enforce this ordinance in their jurisdiction. We are having to update and revise lot and building standards, clarifying staff review authority. There are currently standards dealing with single and multiple land uses on parcels of property. We're having to serve as preserved and protected as the project moves forwards. We are modernizing existing standards and how encroachments in height are measured and dealt with. We are expanding current fence and wall regulations by providing graphics, pictures, and examples, so it's easier to understand for the general reader what they're allowed and not allowed to do. We're also recommending the county consider adopting general performance standards, specifically dealing with noise, air pollution, liquid waste, and there are others. But this is an attempt to try and preserve existing development patterns as well as ensure that one project does not have a negative or as negative an impact on adjacent property as can be. Article 7 starts dealing with the actual development types. You currently have development types within the Unified Development Ordinance. They are typically conventional and planned development. From a subdivision standpoint, we are having to ensure reference to both exempt and expedited subdivisions as defined under state law. As a general reminder to all parties listening to this and reviewing this presentation, there are several categories of division of property that under state law don't qualify as a regulated subdivision activity. This can include creating 10-acre lots, which is not classified as a subdivision. The example I'll give you is if you have a 100-acre tract of land and you create 10 10-acre lots, under state rules, that is not classified as a subdivision. The only thing county staff is doing is signing a document known as a plat produced by a surveyor, memorializing the fact that the activity shown on that document is not a regulated activity. We also have to take into consideration expedited subdivision projects. Under state law, if you have a parcel of property over 5 acres in area and creating no more than 3 lots, the county can only require the applicant to submit what's known as a final plat for review versus going through the established subdivision review process, which would include sketch plan, typically include, sketch plan, preliminary plat review and action, and then final plat. For an expedited project, we can only require a final plan for review so long as that project meets the dimensional standards of the ordinance, and so long as there's a dedicated means of ingress egress for vehicles to access the proposed lots, then the county would have to approve the project. Conventional subdivisions, which is where an individual is dividing property based solely on compliance with dimensional standards, including lot area and lot width, laying out blocks in terms of block length and block width. We are limiting conventional subdivisions under staff review and approval to 50 lots within a 10-year period. That would include residual acreage. If you as a developer want to exceed the 50 lot limit, you would have to go through a conditional zoning plan development process to secure approval. Typically, under the conventional model, there's no open space outside of lots required. We are recommending as part of the process that any floodway or jurisdictional wetlands be classified as a minimum open space or natural area standard, but we cannot compel and require any additional open space beyond that. There's also going to be a requirement in the new LDO, as currently referenced under current regulations, for there to be internal recreation area for residents of the neighborhood. The flexible development option, which we've talked about somewhat already, is a new construct for Brunswick County that would encourage and allow for the clustering of lots with the preservation of open space and natural area, specifically a 30% minimum preservation of natural area, which could be increased based on the proposed development's intensity, specifically the number of lots. The goal is to provide an incentive to developers to actually preserve and protect natural area while giving them the flexibility to cluster the lots, reduce minimum lot size, and ensure that you are not having to over mass grade the parcel, thereby altering drainage patterns for the region in which the property is located. We are creating 2 new constructs, the cottage court or pocket neighborhood construct, which would allow housing to be clustered around open space areas. You are still required to preserve density for the district in which it's located, but the ultimate goal is to reduce development costs associated with the individual housing units and to preserve natural area to the greatest extent possible. Local staff were asked by representatives in the development community and even representatives of several conservation groups to investigate the need and viability of a mixed residential neighborhood. This would be a subdivision development that would allow for multiple housing types, be it single family, multifamily, which could include apartments or condominiums, duplexes, and etc. So we are going to be proposing a mixed-use residential construct where there would be open space, natural area preservation required. There would be percentage limits on the residential development within a mixed-use project. The example I'll give you is if you have single-family development, single-family attached, which is also known as townhomes, and multifamily, you could only have approximately 33% of each development type within a project. We would also have internal buffers and setbacks between different housing options. So, for example, a single family phase of the project would have to be separated by a 20-foot landscape buffer or natural area buffer from a multifamily portion. Why? It ensures that development intensities do not necessarily impact one of the other phases of the project that you're developing, and also allows for not only the natural area separation, but allows for passive recreational amenities within those areas, those setbacks, which we believe would be a win-win for all parties. Next, we get into non-residential projects. What we are proposing would set threshold limits, be it density, square footage on structures, etc., requiring more intensive projects to abide by specific design standards and criteria. The intent is to provide certainty in the review process. If you're going to be proposing X, you have to do Y in order to have X approved. There's also going to be more emphasis in the LDO on staff review and approval. We are encouraging local residents to trust your experts. That's not just representatives of the planning department. That's all members of the county staff, from engineering to inspections to utilities, that have involvement with the development review process to ensure consistency with applicable plans and policies as adopted by Brunswick County. With respect to review processes, it needs to be remembered that the current LDO maintains the development and review process that is currently in place as directed by the county commissioners, the BOCC, in the fall of 2025. We are going to be expanding staff review authority. We will have definitive development requirements developers have to follow in order for staff to approve. County boards, specifically planning board, will still have their review and approval authority over certain projects, specific additional zoning plan developments. I will remind everyone that if state law does change, then we are obligated to ensure consistency with the changed state law and update development review procedures accordingly. Board review required for specific projects through conditional zoning processes of development, if development thresholds are exceeded, is still going to be a mandate of this ordinance, as it is within the current ordinance. So if you as a developer exceed development thresholds, which we're about to review in a moment, you do have the option of going through the conditional zoning process, which has to be reviewed and acted upon in a duly advertised hearing. So the development types from non-residential component can be summarized as follows. There's a minor site plan process where existing non-residential development can be modified. No more than 1,000 square feet of new building area would be the limit. Planned development local business, consistent with current allowances. This would permit 20% of the gross acreage of a site to be developed for non-residential purposes. Next, we have major site plan. At current, we anticipate no more than 120,000 square feet of gross non-residential floor area to be able to be reviewed and approved under this particular development type. We next would then move to planned development, service, and retail. For projects exceeding 120,000 square feet, it would fall into this new development type category, which would see a limit of 500,000 square feet of gross non-residential floor area. We would then move to planned development mixed use, which would involve the development of both residential and non-residential land use activities. There's a cumulative building limit anticipated at the writing and presentation of this document of 1 million square foot. Planned development, office and campus. This could include medical office campuses. The Brunswick County government complex could fall into this. This could include college or university development, and this could include also industrial parks. The limitation on this is 600,000 square feet of gross non-residential floor area. And last but certainly not least, we have the Unified Master Project, a master plan project where a site-specific site plan is not necessarily required, but anticipated land uses are defined. The Unified Master Project is actually consistent with current allowances within the Unified Development Ordinance already implemented by Brunswick County. The key takeaways that you need to remember when we start talking about the residential development types, their location is limited to be consistent with the future land use map and those future land use categories defined within the Blueprint Brunswick Comprehensive Plan. Higher intensity projects are only permitted in specified land use categories. There are also now going to be broadened mandatory design standards. While Brunswick County currently has some design standards and design criteria that have to be observed, we are expanding that list. This would include open space, natural area preservation, perimeter buffers, pedestrian connectivity, architectural design, access management standards, etc. The key takeaway is the more intensive the project, the more design requirements have to be complied with in order for an applicant to get zoning approval by staff. So some additional examples of what some of these development types or development design standards would include. The preservation on natural area, maintaining perimeter buffers along side and rear property lines. There would be allowances for visibility for major roadways to ensure project visibility. We are going to be requiring utility master planning. There's going to be requirements governing the integration of internal and external street networks, which encourages connectivity and helps address traffic flow and congestion. The architectural design standards, we have current existing standards and focus at the request of local staff is broadening the current design standards in order to include more elements that have been identified as being viable by the comprehensive plan and local staff. Traffic impact analysis is going to be completed for the following list of non-residential development type projects, specifically the planned development, service and retail, mixed use, office campus, and the non-residential planned development conditional zoning request. We are going to be making recommendations on the limit of curb cuts, which help control traffic and create more uniform access to street management strategies. This would entail, as shown on this diagram, the creation of service streets to where multiple non-residential projects would utilize the service street to get ingress, egress from vehicles to their site through a shared driveway cut onto major thoroughfares. The goal is to try to help promote and consolidate traffic movements to avoid multiple curb cuts onto local roadways that could create traffic flow problems and congestion. The service street construct is already in place and utilized in Brunswick County. We are memorializing it in the LDO and making it more of a requirement. Several questions have come up during the review of this project concerning traffic analysis. Specifically, will a traffic impact analysis, otherwise known as the TIA, be required before project approval? The basic answer is yes, but it needs to be remembered a TIA is only required when initial review by staff determines improvements may be required. In the new LDU, we're going to have a two-tiered review process, which is consistent with current practices. There's going to be a scoping session between Brunswick County staff, the Department of Transportation, the applicant to look at a development proposal to ascertain and determine if there's going to be any traffic impacts adjacent to the site. We also are going to be, staff is going to be reviewing TIA thresholds with respect to traffic impacts. And if those thresholds are exceeded, then the applicant has an obligation and responsibility to complete the full-blown TIA study as part of the development review. The internal review process employed by staff under the current ordinance is not being changed. We are, however, broadening the scope of this process to ensure that we are addressing traffic impacts for projects moving forward. We are going to have a new Article 8. This is floodplain development. We are updating existing flood regulations to ensure consistency with the new FEMA recognized model ordinance that was released in March of this year. This has been developed in consultation with county staff, including the Brunswick County Floodplain Administrator. We are ensuring consistency with state law and ensuring we're also complying with the downzoning and non-conforming provisions of NCGS 160D, 601D. That was created as part of the downzoning regulation adopted with Senate Bill 382 in December of 2024. While we are looking and investigating the possible application and implementation of design options to address flood issues, we are not going to take an action that creates a nonconformity. We do not believe we have the legal authority under current provisions of state law to do that. We are, however, ensuring that we are making appropriate reference to policy flow as it relates to processing of a floodplain development permit consistent with current FEMA accepted practice. We have already alluded to the fact that we are creating a new stormwater section for the development ordinance. This incorporates what was already adopted by the Board of County Commissioners in the fall of 2025, specifically a stormwater regulatory standard requiring stormwater infrastructure meeting the 100-year storm event. Once the final ordinance has been devised and approved at the local level, InFocus has an obligation and a responsibility to go to state stormwater staff for them to review the project and ensure consistency with their goals, practices, and policies. One question that has come up is whether or not the county will allow stormwater infrastructure within open space preserved natural area. We do anticipate there being a limited percentage, and no, we don't know what that percentage is yet, of stormwater infrastructure that could be within the protected natural area, defined open space. This, however, must be usable area. One of the key factors that Brunswick County has done previously or has done currently is to allow for trails, passive recreation amenities to be around stormwater features. In my tenure as a professional planner within the state of North Carolina, we have seen stormwater control devices converted into bass or fishing ponds for recreational amenities and activities. And this is something that we would certainly encourage and promote. This is still being reviewed on a case-by-case basis, and we are going to have to work with the county engineer to determine what is going to be the most viable. New Article 10 will address streets. We are going to be consolidating all street regulations currently within the LDO into this new central LDO article. Street connectivity requirements are going to be preserved in this article. We are going to be ensuring that maintenance requirements are clarified and explained so everybody knows what they're obligated and not obligated to do. We are establishing a minimum right-of-way for projects moving forward. This will not invalidate existing projects that have already been permitted, approved, and recorded. But moving forward, we are going to be observing a 50-foot minimum right-of-way. When asked why, the blunt and direct answer, it's easier to modify and expand roadwork systems meeting a 50-foot minimum right-of-way standard than it is to try and compel and require and upgrade existing rights-of-way that may be 45 feet or lower in size to accommodate new development activity consistent with both local and state regulations. As a general reminder, all roads will still have to demonstrate compliance with applicable fire code standards for fire apparatus access. That's not something that this ordinance can impact, nor is it something we can change. That's consistent with state law. With respect to Articles 11 and 12, which will be sign regulations and landscaping, under sign standards, we are ensuring that we have content neutral standards complying with recent Supreme Court decisions. We're going to have multiple graphics outlining allowable sign types, what is and is not allowed to be permitted. We are categorizing existing sign authorizations into three-tiered permit processes. There are going to be authorized signs where technically no permits required by Brunswick County, permitted signs which will need to obtain a permit from the county, and a list of prohibited signs where people know what they can and cannot do. We're also going to be addressing outdoor advertising billboards. This will have to be done concurrent with existing state allowances as well as existing regulatory standards to ensure we're not creating nonconformities. Under landscaping, we are going to be incorporating recent staff recommendations on landscape modifications that were investigated in January, February of 2025. This would include a minimum number of trees per each residential lot. We're going to be simplifying existing tables outlining required landscaping, as well as clarifying what landscape is going to be permitted, specifically focusing on drought-tolerant local vegetation that is considered non-noxious. We're also going to be ensuring that we're properly defining maintenance responsibilities of both developers and individual property owners moving forward to ensure that each party understands what their obligations are and are not. As we continue to move forward in this presentation, we are creating a central parking standard. We're not going to be changing any existing parking regulations. I will remind everybody that one of the bills that in focus on local staff are having to track is the potential change in state law eliminating local government's ability to establish and or enforce parking standards and regulations. If this occurs, then Article 13 will practically disappear from this ordinance. Article 14, Administration and Enforcement, is a new article updating existing enforcement provisions. It gives the staff the tools to properly enforce the ordinance. It simplifies current enforcement procedures, ensures proper cross-referencing throughout the updated LDO on where you need to go and find specific standards and policies concerning administration and enforcement. We're also going to be ensuring consistency with state allowances as related to the county staff needs. As a general reminder to all parties listening to this presentation, Brunswick County goes and works with the general public on an enforcement matter as if it was an educational opportunity. Local staff recognize that mistakes can happen or people may not fully understand what local permitting requirements may exist. So enforcement is treated as an opportunity for education as well as working proactively to secure compliance. Unfortunately, for individuals that don't want to participate in this collegial atmosphere of working together to proactively resolve an issue, the staff will and has to, at the required time, ensure consistency with the ordinance by imposing civil penalties or taking further legal actions of the court to compel compliance. But it's important to note that your local staff currently works above and beyond to try to ensure that local residents are made aware of problems and are working together in a cooperative atmosphere to ensure compliance with the code. That is not changing. We are not changing how current staff processes and addresses violations of the code through this LDO update. Article 15, nonconformities. You've heard me mention nonconformities. It is a situation that exists where a land use was legally established, but through a zoning text change or the adoption of regulations, it's made non-conforming or illegal to current standards. We are updating and simplifying current regulations to ensure that we're properly identifying what rights parcel property owners that may have a non-conforming land use still have. I will remind all parties that we are providing two options on this article to address pending state law changes that are going to be reviewed by local staff and the county attorney. We are simplifying existing standards to ensure they are understandable and enforceable and ensuring appropriate cross-referencing. Our ultimate goal is to ensure that if an individual property owner has a non-conforming land use, that they fully understand what their rights are. To not only continue the land use, but limit potential expansion of that land use and still be compliant with the code. This update will make it easier to understand for individuals recognizing what their rights are and are not going to be. Articles 16 and 17 specifically deal with a new centralized section rules of measurement, specifically how the county determines dimensional compliance, how building height is measured, how setbacks are measured, how density is determined, etc. Right now, these standards are actually scattered throughout the current Unified Development Ordinance, and it would make sense to have them centrally located in the new ordinance construct. And then with definitions, we are updating and simplifying existing definitions. We are ensuring regulations are not actually in the definition itself, but appropriately referenced within the ordinance. And we're adding existing definitions for various land uses that currently don't exist. As we get into the conclusion of this presentation, where normally we would have discussions, questions, or feedback, what I want to remind all parties is that per our contract with Brunswick County in focus, We'll be working for a 2-year warranty period. There is no billable associated with this activity, but we are available to county staff for 2 years to assist with the interpretation, application, and potential modification of the LDO. Why is this important? In focus is going to be working with our planning partners in Brunswick County for the long term to ensure that this ordinance is properly implemented and that we're addressing local staff concerns about potential impacts to local residents. The ultimate disclaimer, as I conclude my remarks here today, is that as we continue to see changes in state law, it may impact the completion of this project beyond what's already been done. As I've already indicated, we took approximately 8 months off to try to understand what ramifications were going to be created with various state law changes that were in the works. We may have to do that again, although direction from both Ms. Dixon and the elected officials is they'd like to see the ordinance completed, recognizing that we, during the 2-year warranty period, may have to do additional modifications to ensure consistency with state law. At this time, I want to thank you all for giving us your time in allowing me to present this presentation to you and review the current status of the Land Development Ordinance update process. I'm going to stop sharing this screen, and Ms. Dixon will come back and talk about how you continue to participate in this process moving forward.
Thank you for taking your time to view this presentation of the Unified Development Ordinance Modernization Project, or as we want to call the new UDO, the Land Development Ordinance. We appreciate your interest and participation in this important process. If you have any questions, comments, or would like additional information, please feel free to reach out to the Brunswick County Planning Department. Staff is available to assist you and will respond with questions regarding proposed ordinance questions or any other question that you might have related to planning. We encourage your continued participation and feedback as the county moves forward with this exciting project. Thank you again for your time and engagement.